And I have to say, I have had a couple of disconnections, but we can still get back on quite quickly. It reconnects quite quickly. So unless there's a massive issue, it should sort of reconnect you in it's literally been a minute or something. I'm going to start screaming at Richard if I lose my way, and he's going to start going through the slides for me. So we'll make it as brief as we can. Nice to see you all again. I can't see you in person, but we've got over 70 odd people on already today. So if you've got any relevant questions that you think might be relevant to anyone else, ask them, because we've had some great feedback from these webinars, and additional information after the webinar, feel free to email me. Most of you know me already if you've been logged on before. For those of you who don't, my name's Marie Walsh. I run and own, I'm part owner of my own law firm now called Consilia Legal, and we only do employment and family law. I just do employment, obviously not family. We asked for topics to be covered for the webinar. Settlement agreements came up top, and I think that's why we've got so many people logged on today. So what I'm going to do is run through some basics. I was thinking about this last night. I've done a very basic one before and had quite a few questions. So I'm just going to try and go through settlement agreements from beginning to end. If you do have questions, type them in the chat box. If I don't come back to them immediately, it means I probably will at the end, or Richard will give me a poke. Won't you, Richard?
I certainly will be, yes.
Connected. Oh, he's there. There you go. Right. Okay, so just thinking about this. So when do you think about a settlement agreement then? We normally think about a settlement agreement when we're looking at a dismissal. Okay, so a dismissal can be actual or constructive. So you're actually going to dismiss someone in that you are giving them notice, or constructive dismissal is being alleged. In other words, an employee is indicating that you have acted as an employer in such a way and so unreasonably that amounts to a breach of contract, and it entitles them to resign their employment without giving you notice and just bring a claim for you because of your behaviours, really. Those types of claims are quite difficult. Normally, I act for a lot of employers, and I do give advice to employees, which is something that I still do enjoy doing because I think it gives you a balance. When I'm looking at settlement agreements, I think, okay, what's the reason that this is coming about? I'll come on to the terms shortly. And the first thing I look at is the person an employee who is receiving the settlement agreement or to receive it? Is that a yes or a no? What's the length of service of this person? In other words, do they qualify to bring claims? And I'll come on to that in a second, because things have changed recently, well, in the last few years. I would say probably to minimise the number of claims that can be brought by employees, so we'll just rehash over that. I then say, right, let's have a look at the contractual entitlement. So don't ever enter into any sort of dismissal discussions with anybody or start having a discussion about settlement agreements without looking at what the person is entitled to contractually. I've had so many cases where a company have asked me to prepare a settlement agreement on certain terms for an employee, only later to find out that the employee has produced a contract which indicates that they're due another contractual bonus, or in fact the notice is incorrect. And it's just a bit embarrassing. So always dig out the contract, look at the contractual entitlements in terms of notice. I'll come on to that again in a minute. Then look at what the individual circumstances are. So is there any potential in the exit negotiations for a discrimination claim? And under the Equality Act, there's protected characteristics identified, such as disability, sex, race, the list goes on. Look, is this person that you're dealing with, and do they have any protected characteristics? Is there any potential for a discrimination claim? And I'll tell you why that's relevant in a while. Then look at your reason for the dismissal. So most common reasons for exiting people under a settlement agreement are not conduct. A lot of conduct issues are simply dealt with on a straightforward basis. Settlement agreements normally come about if there's capability issues, if there's sickness absence issues, or you might come across different ones, but in the main those are the common ones. And then also look at your own procedures and what the company handbook says. So before you start anything, have a look at dismissing people, the basics. Get the contracts, your handbook out, look at the individual, get the personnel file out, no problem. So when we've had a look at that, looking at length of service, remember unfair dismissal. To present claims for unfair dismissal or constructive dismissal in a tribunal, an employee now needs 2 years qualifying service. Okay? As an employer, in order to dismiss someone, you have to show one of the 5 fair reasons to dismiss. So capability, conduct, redundancy, some other substantial reason, illegality. Okay? And that's section 98(2) of the Employment Rights Act 1996. Secondly, if you're going to dismiss somebody, you've got to show that you've acted reasonably in light of the size and resources of your business. And again, you might think, well, this isn't relevant to a settlement agreement, but it is, because when a claimant or an employee goes to seek legal advice on the content of a settlement agreement, the solicitor who's advising them 9 times out of 10 will establish, have you got any claims, looking at all these issues, and then they will, although they're not obliged to do so, in most cases make a rough estimate of what those claims might be worth if the person went to an employment tribunal vis-a-vis accepting a settlement agreement. So if you've already got this in your mind before you start, it gives you a good starting point when you're negotiating. As I've said, the main problem areas I see with settlement agreements surround capability and performance, attendance issues, and disability. Okay, I had a recent issue with a chap who had early onset Alzheimer's, and that was a difficult exit to manage. But of course, the company wanted to do the right thing, and we ended up entering into a settlement agreement, and that's all progressed quite nicely actually, and quite amicably because of the way it was dealt with. So in that situation, a settlement agreement was a great idea. Now, you're deciding you want somebody to exit the business. You've already assessed everything, so this is what we can and can't do. If we were exiting, this would be the reason, this would be the process. But let's shortcut that. Maybe we can just enter into a settlement agreement. And of course, you can use settlement agreements to compromise ongoing claims as well, but I'm going at it from this perspective today. Now, settlement agreements used to be called compromise agreements. Remember, that name changed in 2013. Do update your precedents if you haven't already. I've seen a few recently that have not been updated, where the company is simply rolling out an old standard form. Just make sure you've got your new settlement agreement up to date, because it has come up with some updated clauses to make sure it settles all claims and settles conditions relating to settlement agreements and compromise contracts. So have a read through your settlement agreement. Don't just roll out your old precedent. Now, in order to bring this conversation up with the employee, it normally comes about one of 2 ways. So it'll come about as a result of a without prejudice conversation or a protected conversation. Now, we did run a webinar once about protected conversations when they were quite new. These came around quite recently, everything's quite recently really, but I'll start first with without prejudice. So the first question a lot of people normally ask me is, well, I don't know what to do. Shall I do it, shall I say without prejudice, or shall I say this is a protected conversation? And my answer to them much depends on what the person that we're dealing with and whether there is an existing dispute. So in general terms, if there's an existing dispute to settle and you want to try and settle that, then to have a without prejudice conversation is fine. So there's generally got to be the absence of an ongoing dispute, let's say. If you've got that dispute and you speak to somebody without prejudice, legitimately it means that the conversations are not disclosable in any future proceedings. So you can speak more freely. It's like having 2 lines of communication. If you think of a set of parallel lines, you'll have the top line of communication being your open correspondence, which might be, I'm going to exit the person, these are the grounds, you're not performing or whatever, which will be legitimate. And then underneath you'll have the second line, parallel, which is without prejudice, and that will be where you can say to the person, look, I will follow this process because it's legitimate, but off the record and without prejudice, we might want to discuss another exit. And that's an entirely legitimate way to introduce the concept of a settlement agreement. What I would say, and this is a common error again, is that I have dealt with some companies who, before they come to me, they'll mark correspondence they won't mark correspondence. So they might send an email to the employee saying, do you want a settlement agreement? But they've not marked the agreement or the email without prejudice. And any without prejudice correspondence has to be marked without prejudice, subject to contract. Oh, I've just been kicked off.
Still there, Marie?
Oh, back in the room. Can you hear me?
Yeah, I can hear you. Yep.
You can still hear me, okay.
Yeah.
So if you are going to have a without prejudice intro to this, do mark all your correspondence without prejudice subject to contract, please. That's fine. And then afterwards, then that correspondence is off the record, subject to you conducting any improper behaviours, which I won't go into now. Clearly, you shouldn't be blackmailing people and putting undue pressure on people, really. But anyway, that's the one thing. Then a protected conversation was introduced, as I say, recently. It's under section 111A, so 111 capital A of the Employment Rights Act 1996. And that is another way to discuss exit with individuals, but that really only applies to ordinary unfair dismissal proceedings. So if there's any threat of a discrimination claim, rightly or wrongly, my advice to people is stick to a without prejudice conversation. If it's a straightforward, look, this this isn't working out, then you can enter into a protected conversation. And this protected conversation arena was supposed to make things easier for employees, just to have a conversation about exit where it's straightforward, basically. And there's lots of guidance on the ACAS website. There's even precedent letters. If you're going to do that, though, do follow the guidance. You're supposed to give relevant notice. There's guidance about whether people should be accompanied at a meeting for a protected conversation, which doesn't apply to without prejudice. So I would say read the ACAS guidance on that if you're going down that route. Okay, so let's say you've had the without prejudice conversation with the employee. You've put it to them that there is another amicable way to resolve an issue or to exit the business, and that would be a settlement agreement, and they've asked for a copy of it. Okay, all settlement agreements have got to satisfy certain statutory requirements. Okay, so in relation to the statutory requirements, really the agreement has got to be in writing. It's got to relate to particular complaint or particular proceedings. So as I said, it could settle an ongoing claim in the tribunal. Similarly, you could go through ACAS, but in this scenario. And you will see in relation to general settlement agreements that there's a list in some of them of claims, every claim which could ever be settled using a settlement agreement in the back of the agreement. It's normally in a schedule, and it does specify in there the complaints which the agreement is meant to satisfy. Also, in order for it to be binding agreement, the employee must have sought legal advice on its terms and on the effect of the agreement's effect on the employee's ability to pursue rights before an employment tribunal. In other words, once they've signed the settlement agreement, they are prevented from bringing claims in an employment tribunal. That's the key piece of advice. Two things about this. The advice has got to be sought from a relevant independent advisor. And that can be a solicitor, but it could also be a trade union advisor. And what I would say is if you've got a trade union advisor, make sure you get their certificate, because they've got to be certified as competent to give the advice. And also, the employee could seek advice from a voluntary sector advisor as well. Okay? Now, going on from that, the advisor must be insured and identified. So the agreement must say who the advisor is and identify them. Just a word of caution, I've only ever had it happen once, but I did once have an employee take away a settlement agreement from a client of mine and bring it back certified by his brother, who said that he was an insured advisor, and of course he wasn't. So we did have to check up on the firm. It did come back on some very convincing letterhead, I have to say. But I would always say, if you're slightly unsure if it's not somebody well known to you, just check that they are qualified to give the advice. We wouldn't want to fall down on that. Okay. The agreement must state that the conditions relating to settlement agreements and the statutory provisions have been satisfied. So you will see some standard clauses in there. So when you see a settlement agreement, generally there are some standard terms, and this is why, because it's got to comply with the statutory requirements. Okay. So once you've decided that you're going to do your settlement agreement, you make sure it's compliant, you've routed it out, run it past your advisor and said, just checking that this is up to date. What are the terms then, standard terms in a settlement agreement? So we've got some standard terms here. The agreements generally provide for an agreed termination date, and that obviously, as the name suggests, is the end date of the employment. So the agreement then normally provides for payment to a termination date, and then maybe payment of any accrued holidays that the employee hasn't had a chance to take, or recoupment for overpayment of holidays maybe. So, it doesn't always mean you have to settle up. It then also takes into account normally payment of notice or a payment in lieu of notice. And that's, again, going back to, you'll already know about this because before you've gone into it, you've checked all your contractual terms. It might also include any restrictions or a reiteration of any restrictions. So in relation to payments in lieu of notice, for example, if you make somebody a payment in lieu of notice and you haven't got the right to do so in their contract, then technically you've breached the contract, okay, because you've done something that you're not allowed to do. Just one of those things. If that happens, though, then if that contract does contain any restrictions, then arguably you lose the benefit of the restrictions because you breached the contract. So in a lot of settlement agreements, if you do need to restrict someone, I think you need to reiterate them in the settlement agreement and give some consideration. So you might sometimes see a settlement agreement with, say, an extra £100 or £500 in there to compensate or to give consideration for re-entering into restrictions post-termination. Also, in relation to confidentiality, you can have a provision in there to keep the agreement confidential and also to reiterate confidentiality provisions in any contract. And also, it's very common to have a non-derogatory comments section which works both ways. I mean, I normally say make things reciprocal, okay? So if you've got confidentiality provision on behalf of the employee, make it reciprocal, agree to do the same insofar as you're able as a business. And the same with non-derogatory comments, because that's one of the things that people come back on all the time. And what's the point? You might as well cut the costs and just make the agreement fair. That's just my view. And some people like a good fight, and I just think it's a cost ranking exercise, which is quite boring. Okay, so often also, and I've missed this off here, the reason for the termination is sometimes included. So, if it's a genuine redundancy situation, for example, and you're just, giving somebody a golden handshake or, you want to just tie it neatly off or you give settlement agreements out as a norm, then, it's quite normal sometimes to put in there that the reason is redundancy. Okay, I'm getting some questions here, so I'll come back to that in a minute.
Okay.
Got a question there, and we've lost somebody there.
You've got two. There's two questions from Sally that you've got that are on the bottom of the chat.
That's fine. I'll come back to them, Sally. So, other standard terms, what you'll often find in there is a tax indemnity, which basically says we think a certain amount of your payment is tax-free, and I'll come on to payments in a minute. But if it's not, or if we have any trouble from the revenue, or if we're approached, or if we've done anything, that's deemed not right, then we can pursue you as a company for return of the tax or any penalties or costs. So that's quite a standard clause. The agreement normally deals with return of company property, and I'd say be careful there. I've had so many people who have used standard settlement agreements that don't cover certain types of company property for that individual. So think about what the individual has that is of value to the company. Don't just roll out a standard. If people have got things on disk or valuable company information at home, do they work from home? If they've got a special laptop or a tablet that you need back, make sure it's specific. Also, don't forget to include anything to deal with resignation of directorships or offices, and often of a lot of importance to an employee, particularly if it's not sort of a redundancy or an amicable exit as such, is a reference and in an agreed form, and often an announcement which would go out internally and externally. I've seen settlement agreements with both that have been agreed as part of the package to put people's minds at rest. Normally an agreement is in full and final settlement and without any admission of liability. And also, it normally does not settle any claims of personal injury nature of which the employee is not aware when they leave employment, so latent personal injuries we call those, or any accrued pension right claims, so pension still untouched. It can still include, though, personal injury claims of which an employee is aware before they leave, but you need to be specific about that, so it can exclude them, and also claims in relation to injury to feelings that might arise out of any potential discrimination claims. The other thing that I haven't put on the slides is what people are doing more and more, I've found this year actually, is that they're coming to an agreement with people to leave and then keeping them working for, say, 3 months and then asking them to reaffirm a settlement agreement at the end of that 3 months. So they enter into the agreement saying now the person is to leave in 3 months, and at the end of the 3 months they ask the person to reaffirm the content of the agreement. In other words, to say that nothing has happened in those 3 months which has given rise to a claim, as in from the date of the last signature. So you might see, or you might need a reaffirmation certificate, and you might want to take your advice on that. So, back to the question then, we'll just have a break. Should you only use the section in protect only, not without prejudice? Okay, so yeah, the section 11A is 111A is about protected conversations only. That's right, yeah. So without prejudice conversation is separate to that. So you're either having one conversation or the other. We've got an issue here with the audio, I think.
Yep. A couple of people are having a few problems.
Might have some people in and out there. So yes, you would definitely, it's either one or the other. You're having a protected conversation or without prejudice conversation. And what if, I'm not sure I understand that second question. The restrictions are not in the contract originally. So if you don't have any restrictions in the original contract of employment, which you'll have checked, of course, I can't say this in as many times, then you can still introduce them into a settlement agreement when somebody leaves. But again, you would have to put some consideration towards that. You can execute the document as a deed, but what I would say, take some particular advice on that, just to make sure it's binding. But yes, you can introduce restrictions afresh, as it were. Now I've got, do we need to know the details of the advisor prior to drawing up the settlement agreement? No, you don't. So in a lot of cases, we present settlement agreements to people and we say, look, here's your agreement, take it to see someone and ask them to get in touch with us, okay? I normally send a hard copy of the agreement with an employee, and I'll say in the covering letter, these are the details of our advisor, i.e. me, can you ask your legal advisor to contact ours? And then what normally happens is the agreement is sent between myself and the legal advisor for the employee, and any changes are made between us and marked and tracked. So you don't have to know beforehand, no. And one thing I would say about the legal advisor is the advisor shouldn't be related to your company at all. And I've quite a few individual companies in the past who have approached me who have given recommendations of legal advisors, please use this particular person for advice on your claim. I think you've got to be careful about that. It's fine if the person wants to use them and they're completely independent to the company, but I would say always offer a good representation so they've got a choice. You don't want to be seen to be pushing the employee somewhere where there might be an accusation of lack of independence or something. Bear with me, I'm just going to have to go through the chat box because I've started the questions going now and I'm on fire. Let me have a look. Woo!
So if you go back up,
right.
I think we've got...
Right, so I'm now, it's okay. Then I've got, no, I've done that one, I think. Yeah, I've just done that one. Okay, so I've just written a settlement agreement. It's just out of the line. I don't really understand about personal injury. Yes, you can check it with me. Do you want to email it to me afterwards? If you don't want to, yeah, that's fine. I
think I've made it available to everybody now.
And then we've got, in terms of restrictions, if there's no mention of pylon in the contract, how do you deal with this in the settlement? Okay, so if the contract doesn't allow for you to pay in lieu of notice, so there's no payment in lieu of notice clause in the contract, then what you do is you can still make a payment in lieu of notice, but then reiterate the restrictions in the settlement agreement itself and give some consideration for that, as in monetary consideration. That amount of money that you apportion to the restrictions is taxable, as far as I'm aware. Of course, I'm not a tax advisor, so you can't quote me on that. And this is, of course, totally non-insured advice. I just need to add that. Next one, is it advisable to enter into a settlement agreement Yeah, so if you've got somebody who has acted in a way outside work which is inappropriate and you would like them to leave, you can make them an offer of a settlement agreement. You can make anybody the offer of a settlement agreement at any time on a without prejudice basis if there's an issue and you would like them to go. Whether or not they'll accept it or not is an entirely different matter. Of course, in issuing a settlement agreement, you can never be sure that the person you're presenting it to is of a similar mind or will be minded to enter into it with you. But of course, you can always make a proposition to someone if you're in a dispute, even if it's about a matter which has occurred outside the workplace. So yes, quite happy with that. Should a settlement agreement always have the value of money, for example, holidays? I see what you mean. So you're saying if you're going to pay someone an amount in lieu of the holidays, well, the usual wording in a settlement agreement for that would be that the employee is paid up to the termination date and made a payment in relation to accrued but untaken holidays up to the date of termination. And that would be fine in itself. Some employees do then come back to say, look, I think I've got 7 days, and that equally it's then fine to say up to 7 days. Equally it's fine to put the amount in, and I've seen it done everywhere. It depends a lot on the matter of trust. I've acted for individuals who have been wanting specific figures, and I do understand why that might happen. I've acted for other senior executives who were just, well, I'm not bothered, I think I'm owed 14 days, I'm sure that's going to be fine, it's a payroll matter, so I'm happy either way. Yep, my email and details are all going to be at the end of the presentation. You have to pay benefits compensation when paying payment in lieu when not providing the contract. Well, you normally do. So what you normally do if you're making a payment in lieu of notices, you have a look at what other benefits would have accrued during the notice period. It depends on the wording of your contract, does that. So, it's probably quite specific. Yeah. So anyway, right. I'll move on for a second and then we're on half past. Right. This is the other question I get asked all the time. So people ring me up, right, Marie, you've been doing it 15 years. Tell me what to offer this person. I just want it sorting out. So obviously I go through all this rigmarole with each client about, well, send me the contract, let's have a look at the file. And then what do you offer? Each case is totally individual. I said there's a picture of somebody there, and then the other picture, which you can rarely see, is meant to be a little reference. I must have executed 1 million, well, not 1 million, but hundreds of settlement agreements over the years and compromise agreements. And in some cases, people have been happy to leave for a reference, and that's all they've wanted. They just want to leave with a clean reference for whatever reason. A lot of it depends on the nature and the reason for the dismissal, and that's why I said that at the beginning. I've also acted for individuals who have left for enormous amounts of money, and again, because of the nature of the exit, and that might be because they've been, hideously harassed in the workplace by a co-worker, or they've been dismissed unfairly, and the company have decided to settle that potential claim because they know they're exposed. A lot of it also depends on the level of earnings of the individual with whom you're dealing. What I would say to you is, and going back to the beginning of the slides where I said I would relate it back, is look at what potential claims, my advice is always look at what potential claims the person might have, okay? Then look at and speak through with your advisors what the potential value of those claims are. At the moment, the value of claims to individuals has been significantly reduced. So, for example, a standard unfair dismissal claim for a claimant in the absence of any discrimination or other issues is limited to a basic award, which is the same calculation as a statutory redundancy payment, so based on age and length of service and gross pay, and also a year's pay. So if you have an employee who is earning less than 78,000, which is currently the cap, give or take, then the maximum exposure for that year's pay or for the ongoing loss element is not 70,000, it's a year's pay. So you might have somebody who's earning 20,000. Well, that would be your maximum exposure. So just take proper advice about what your risks are, your exposure if the matter was litigated, and then do a calculation and come to a decision in each case with your advisors as to which is the relevant amount and what's fair. I've acted for companies who like to start ridiculously low, knowing the offer's not going to be accepted, and then pay legal fees to me, which is great, of course, to negotiate upwards. That's fine. It can be a bit of a waste of money, but each to their own. I've other companies who say, look, I think this is a fair offer. That is my offer. It's a take it or leave it offer. I'm not prepared to negotiate, and that's because they've taken what they consider to be a generous view of settlement. So each individual, it's impossible to answer that question, but as I said, do give guidance, but I'd have to look at each individual case. I would also say that in relation to finances, don't forget that the company normally contributes towards the employee's legal fees or fees in taking advice on the agreement. And that can be anything from £250 plus VAT upwards. Don't be over generous on it if you're an employer. You're paying for the solicitor to give advice to the employee along the lines of, these are the terms and you can't claim once you've signed it. You're not paying for the employee's solicitor to fight against you on the exit. If they want to fight against you and they're keen on doing that, or they feel they've been treated unfairly, then they must bear the costs of that generally. Just be aware. I probably would avoid overpaying. Saying that, you don't want to really pay less than £250 at the moment. That seems to be a sort of standard, going up to 500. It depends on the level of the person and the complexity of the agreement. Other considerations when you're looking at settling people is, remember, in relation to bringing claims, the employee has 3 months from the date of the dismissal or the date of the last act of discrimination that they complain about to bring the claim. So if somebody's complaining about something which is discriminatory, which happened 6 or 12 months ago, and there's been nothing since, think about time limits and whether you are actually even exposed. The other thing I would say is, if you've dismissed someone, remember they have to contact early conciliation now before they can bring a claim. So you probably get the heads up from ACAS even before you consider a settlement agreement. And you can settle claims through ACAS, remember, and that might be a less costly way to do so. You, as an employer, can also contact ACAS with a view to settling a claim after you've dismissed somebody, which a lot of people seem surprised about, but it's not, well, it is unusual, but employers do sometimes contact ACAS and say, right, we've dismissed this person, we want to enter into an agreement with them, and we'll do it through a Cont 3, which is another way of settling claims, and ACAS can deal with you that way, so that might save some legal fees. Not that I want to do myself out of any business, but I'm always doing this. That needed to be a bit more robust. Yes, we all want. Anyway. Right, so I've got some more questions here. So is a reference prepared by the business, or is there a general one? Normally a reference in a settlement agreement is agreed between the parties. A lot of businesses I act for now do just give standard references, which will say, the person worked here between X and Y, this is the role they did, and we don't accept any liability for the reference, basically. And there are some very good standard references, which again you can probably get from your advisor if you're engaging them in the preparation of the agreement. When entering into a without prejudice conversation, would you mention why you're entering into the conversation with the employee? In other words, I suppose what you're saying is, do you just give them the agreement, or do you have a conversation with them to say, look, we've got these issues, and or this is another option? Well, it's horses for courses, but in general terms, I've found that the approach that's worked best over the years is just to be straightforward with people and to say, this is what's going, this is potentially an issue for us, this is what's happening, or these are issues, another option is this. So yes, I don't think there's anything wrong with that. I mean, of course, unless you're going to be saying something which is inappropriate, which I'm sure none of you would. There you go. So, you tell me about the government's pension tax element of which currently may be paid free of tax. In relation to that, the next question, I've had a question about the government's plans to change the tax element of the agreement, the 30k, which may currently be paid free of tax. To the best of my knowledge, the 30k can still be paid free of tax, but there's going to be changes to what you do after the 30k in relation to national insurance. which I would need to look into if you wanted to know more about that, because I haven't got my head around that yet. I mean, what I would say in relation to any tax or other issues on the agreement is take proper tax advice, because 9 times out of 10, unless your solicitor is a qualified tax advisor, they won't be able to advise you properly on the tax, and I don't think they'll be insured to do so. So, to my knowledge, it's above the 30k, but I haven't looked into it, so I'm sorry about that, Gary. I could do if you wanted me to, or you could speak to the accountants, that's probably best. So we've got a disconnection, and then we've got somebody here saying they can't see any questions. No, you can't see the questions because I think they're all private to presenters.
Yes,
but we can put the questions. We can get the questions across later, can't we, Richard?
Yeah, we will do.
Yeah. So that's all right. Okay, hang on. Okay, so then the next slide was my question slide, because I've overrun slightly. I think we've had the questions. I'm happy to have questions. It's a tricky area for people to ask questions about, as is redundancy, for example. I'm happy for you to email me afterwards if you've got other. There you go. So I've got there. There you go. No, we didn't know. It wasn't intentional, Rachel, that the questions were private to presenters. I think it's just a teething thing. My details are all there. You can contact me on email. Link in with me, or just give me a call if you need any advice. It's all good. Do you give people a cut-off for signing an agreement? Yes, sometimes we do. If you're having a protected conversation with somebody, then the guidance is 10 calendar days to give them to consider it. Okay, with or without prejudice offer, I've had, as long as you're not giving ridiculous amounts of pressure, I've acted for companies who say, on a Monday, this is your agreement, can you come back to us by Friday in principle if it's accepted? I have other companies who say, we need it signed back by Friday or it's off. And remember, any counter offers on a settlement agreement are classed as a rejection of the initial offer, so there is always a chance for you to take the offer off the table once made if, before it's accepted. So just think about that if you have any particular issues.